Major breaking news out of the Trump administration. It appears that a working group has been formed within the Department of Justice to, ready for this, folks, restore Second Amendment rights across this great country. You're not going to want to miss this story. Big news. I'm not surprised. Exciting news. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment thanks to your support at the 2025 Gundies Awards. Thank you again for all you do, for helping us bring you what we try to bring you, which is the best Second Amendment news out there in the geekiest way possible. All right, folks, so here's the story. Very exciting news. And I think the start of great news for the Second Amendment throughout this entire Trump administration. The New York Times has just reported that the Department of Justice's longtime pardon attorney, Elizabeth Orr, has been dismissed. According to the New York Times, she claims that she was dismissed because she would not sign off on the restoration of the right to keep and bear arms for Hollywood actor Mel Gibson, who in 2011 pleaded no contest to a misdemeanor charge of allegedly battering his former girlfriend, never went to prison, paid like a $500 fine. I don't think there was a trial or any finding of fact or anything back in 2011. And since then, Mel Gibson is trying to acquire a firearm, but is not able to do so because of federal law. Now, the reason why this story is particularly significant is not about Mel Gibson per se. It's actually about the reporting of the efforts by the Donald J. Trump administration to expand Second Amendment rights with a working group within Attorney General Pam Bondi's Department of Justice. This is going to connect a lot of dots, folks. A lot of things you've heard about on this Four Boxes Diner channel and my writings is all going to get connected up in a very positive way to show that the Trump administration is going to advance Second Amendment rights across the board. Specifically, according to the reporting from the New York Times, there is a working group of lawyers within the United States Department of Justice that is reviewing applications and information about people that have been convicted of crimes who should have their gun rights, their Second Amendment rights restored. Why? Because according to the reporting, which I'll read you some excerpts in a moment here, why? Because these individuals do not pose a danger to society. Now, this is all going to connect some dots for you of things you've heard before. Specifically, as you know, last summer in 2024, the United States Supreme Court decided the United States versus Rahimi case. And this is going to show you how these precedents all add up to really help us out. In the Rahimi case, you may recall that Mr. Rahimi himself, who had bashed his girlfriend's head against the dashboard of his car and had engaged in 5 shootings, according to the allegations of what he admitted to, that caused him to lose his gun rights under 18 U.S.C. 922G, federal law dealing with prohibited people. Mr. Rahimi himself lost that case before the U.S. Supreme Court. But as I've explained to you before, when it comes to our right to keep and bear arms and other constitutional rights, it's not just about who wins the case. It's equally important, if not more important, how a person wins or loses the case. And in the context of the Rahimi case, a lot of people were very upset with the Supreme Court for supposedly throwing the Second Amendment under the bus. And I said from the start, that is hooey, that is not true. The Rahimi case is very good for the Second Amendment. It is a pro-Second Amendment decision, and we're about to see the Trump administration take advantage of it. And how so? You may recall for the Rahimi decision, they said that a person can be disarmed. A person can be disarmed if they are found by a court to be a danger, a violent danger to others. Finding by a court that they're a violent danger to other people. And even if that is found to be true, even if that occurs, the Rahimi decision by the U.S. Supreme Court said, you can only be temporarily disarmed. Finding of dangerousness, you're violently dangerous, and you can be temporarily disarmed. Now we're seeing, according to the reporting by the New York Times, and I'll give you the excerpts in just a moment, that this working group working on behalf of Attorney General Pam Bondi and President of the United States Donald Trump is using the precedent of Rahimi to look around the world or look around the country for instances where people have been disarmed and lost their right to keep and bear arms, but should have those rights restored. Here's what some of the reporting says. And again, these dots are all getting connected up. Here's the first thing that the New York Times says about this effort by the Trump administration to restore rights. About 2 weeks ago, Ms. Orr was put on a working group to restore gun rights to people convicted of crimes, she said. That effort has been championed by some on the right who maintain that not all people with criminal convictions are dangerous or deserving of such a ban. Others contend that doing so, particularly when it comes to people with domestic violence convictions, carries significant risks. Does that sound familiar? It should, because in addition to being part of the Rahimi discussion, you've also heard about that kind of gestalt, that sort of language, that methodology of understanding that just because someone's been convicted of a felony does not mean they should be disarmed for the rest of their lives and lose their Second Amendment rights. Not only have you heard that in the Rahimi case, you almost certainly heard it from the decision by Judge Thomas Hardiman on the U.S. Court of Appeals for the Third Circuit in that en banc decision in favor of the Second Amendment. In the Brian Range case, where Brian Range lost his Second Amendment rights for life because something like 3 decades ago, he was convicted of a Pennsylvania misdemeanor for some sort of welfare food stamp fraud for a couple $100 or something, and yet lost his gun rights for the rest of his life because under that particular misdemeanor statute in Pennsylvania, he theoretically could have gone to prison for more than 2 years, even though he never spent a day in prison. And that caused him to be disarmed for life under federal gun control statute 18 U.S.C. 922 G1. And likewise, now you're going to see how everything gets connected up again. Judge Amy Coney Barrett, that's right, Judge Amy Coney Barrett, who is now Justice Amy Coney Barrett, got all of this ball rolling in 2019 in the Cantor versus Barr decision when she dissented in a case dealing with nonviolent felons on the Seventh Circuit Court of Appeals. Judge Amy Coney Barrett wrote that nonviolent felons cannot be disarmed for the rest of their lives, and that is not because that is not consistent with the text of the Second Amendment and the history of the Second Amendment. It was Judge Amy Coney Barrett that got all this ball rolling in favor of nonviolent felons, and that precedent of her dissent has been relied upon in many subsequent cases thereafter, including Bruin, by the way, and her dissent was discussed even in the Range case by the Third Circuit. So again, you can see how the things we talk about on this channel all get tied up. And as a side note, I should mention, when I put out a video that says in the thumbnail, huge breaking news or major breaking news, it's because it is. Now, it may not be obvious to ordinary folks out there outside of the Second Amendment community, but a lot of the things that are major breaking news are victories. There are specific battles to be won. Because remember, if you want to invade Japan in World War II, you got to take the beach. You got to take the airways. You got to take the airport. You got to take the hills around the airport. You got to capture these specific battles and then take the island. And from that island, you can ultimately, over time, get to the island of Japan. You can get to Japan. So when I say something is major breaking news, you may be like, hey, what's the big deal? The answer is because it's a major victory over a particular battle that we need to win the war for our rights. Like a dissent in Cantor versus Barr, the decision in Range, and now the firing or dismissal, according to the New York Times reporting, of Elizabeth Orr, the pardon attorney, by the Trump administration because she was not sufficiently pro-Second Amendment or not willing to expand restore the Second Amendment rights of Mel Gibson, for example. These are battles that we have to win the war. You don't just win the war overnight. You win battles that give rise to winning the war. So when I say something is major breaking news because we've won a major battle, you should assume that is true. It's not clickbait. That's the reality. Okay, now with that said, let's go to the other critical thing that the New York Times is reporting about this working group to restore Second Amendment rights in America. Ms. Orr said she was told that a small batch of people to get their gun rights back would be the first step toward a broader policy goal achieved through rewriting Justice Department regulations to more clearly give that power to the Attorney General. This is huge, folks. This is huge, because what this is saying is that the Department of Justice is going to redo their regulations about who can have their Second Amendment rights restored. And they're going to take that away from a bunch of unelected DC-based deep state bureaucrats who won't want anyone armed other than the police, other than the government. The fact that it is being taken away from deep state regulators and bureaucrats, as far as that's how I interpret that language from the New York Times, is great news as far as I'm concerned. But the New York Times goes on to discuss this new policy by the Trump administration in favor of the Second Amendment. This is the next thing the New York Times writes. Within the working group, the government lawyers seem to generally agree that a significant period of time since a conviction should have passed for someone to be eligible for such relief, perhaps 10 or 15 years, and that it should not be extended to convicted murderers and armed robbers. But the issue of domestic violence proved to be a sticking point, particularly when it came to Mr. Mel Gibson. Again, the fact this conversation is occurring, the fact that a new policy is going to be set by this administration in favor of the Second Amendment is a really, really big deal and a positive sign of where the trends are going. And as you know, right now when it comes to the Second Amendment, the trend is our friend in Washington. Let's see what else the New York Times has to report about this expansion of the right to keep and bear arms. And really, it's not an expansion, it's a restoration of the right. Ms. Orr said she was told that the working group would generate a list of candidates to get back their gun rights as part of a longer-term effort to have the Attorney General restore such rights to some individuals. Her office, she said, came up with an initial batch of 95 people she considered worthy of consideration, made up principally of people whose convictions were decades old, who had asked for the restrictions to be lifted and for whom Ms. Orr's office thought the risk of recidivism was low. Powerful stuff. Again, great news out of the Trump administration. I think this is the start of big stuff. This is the start of what's going to be a series of huge wins. Just as a side note, historically, there is a federal statute overseen basically by the ATF for the restoration of rights. That office has been defunded for the last many years because the Democrats don't want people getting their gun rights back because they hate the Second Amendment. And Republicans, historically law and order Republicans, don't want criminals to get their gun rights back. So that office, that law has mostly been defunded for the last many, many years. But it's pretty clear that the Trump administration, to advance the right to keep and bear arms, is going to get that addressed. And I'm happy to say this is great news. And again, what the Trump administration is doing is entirely consistent with the Supreme Court's precedent of Rahimi and the dissent in Cantor versus Barr by then Judge Amy Coney Barrett and Judge Thomas Hardiman's decision in the U.S. Court of Appeals for the Third Circuit in the Range case. So again, you can see how all these little precedents get added up to build a wall to protect our constitutional rights. Every precedent, whether it be by the executive branch in the context of Donald Trump pardoning clemency, a restoration of Second Amendment rights, or whether it be precedents in the form of court cases, all add up. Each is a little brick in the wall that we want to build around our Second Amendment right to keep and bear arms and all of our constitutional rights and liberties for that matter. So there you have it, folks. Hope you learned something here today at the 4 Boxes Downer. Make sure you subscribe to X at 4 Boxes Downer. Don't forget to subscribe both here on YouTube and Rumble, trying to get to 200,000 subscribers on YouTube. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.